Namaskar. I'm Advocate Biswajit Das. As we all are entering into a new era of practice, new era of legal governance of this country from tomorrow, with effect from the 1st of July 2024, where the Government of India is bringing 3 new laws: the Bharatiya Nyaya Samhita, Bharatiya Nagarika Suraksha Samhita, and then the Bharatiya Adhiniyam Sakshya Adhiniyam. And these 3 new laws, which is enacted by the Parliament, now is getting effected from the 1st of July 2024. And these 3 new laws are in lieu of the old Indian Evidence Act, Indian Penal Code, and the CRPC. And if you want me to narrate these 3 new laws as a concept, I'll tell you that this is nothing, I repeat, this is nothing but old wine in a new bottle. Only the name is changed, the content is almost identical to the extent of 99.5% of its content are identical. Mark my word, 99.5%. The changes that has happened, for example, the Indian Evidence Act. In that, the changes is only one, that is the digital evidence is given the primary status, that is treated as a primary evidence as opposed to the secondary evidence earlier. So, digital evidence, digital statement, digital signature, digital documents. This is only the change in the Indian Evidence Act. Second change is that this particular digital evidence of the statement is given the primary evidence status as opposed to the secondary evidence status. Barring this, there is absolutely no change when it comes to the Indian Evidence Act. So you can imagine that out of 164 sections of Indian Evidence Act, only this much of change has happened. So only one section is added there. And if you similarly see the Indian Penal Code, similarly the Indian Penal Code also, the definitions given in different sections are clubbed together in one section, and the penalty and the fines, the quantum of penalty and fines of all those offences in the Indian Penal Code are only enhanced. This is the second change. Third change is the Terrorist Act is defined newly. Similarly, organized crime is defined newly. So barring these changes, there is absolutely no change in even the Indian Penal Code, which is now, earlier it was Bharatiya Danda Adhiniyam, now it is named as the Bharatiya Nyaya Adhiniyam Samhita. Same way, if you get into the CRPC, which is now the Bharatiya Nagarika Suraksha Samhita, even in that, only the procedural changes have happened, which we have borrowed as a concept from even the judgments, like for example Zero FIR. Even though Zero FIR as a phrase was not legislatively designed or contended in the Indian your CRPC, but that is now a new only addition of legislative text in the Adhiniyam, the Suraksha Adhiniyam. That's the one change. Second is your relay bail, which earlier it was not there. But these are the concepts of Zero FIR and the relay bail. These are the concepts anyways are borrowed from the judgments of the Honorable Supreme Court. So these are the broad changes that have happened. Also, the new Adhiniyam is talking, your Samhita, your Nagarika Suraksha Samhita is talking about expediting the proceedings before the court. Now only that also, let me tell you, practically it is counterproductive. This, as you all are aware, that the Indian insolvency bankruptcy court, if any practitioners will be watching this, they know that every provision is talking about, like for example, admission of operational creditors applications or the your financial creditors application within a period of 14 days, admitting it within 14 days never happened in reality, because the concepts that we are designing to expedite the proceedings is certainly not achieving its desired objective. Reason being, there is a structural deformities are there, there are distortions are there, and this particular law, for example, these 3 new laws, except the fact that its name is changed, And these cosmetic changes happen, which the government could have achieved through amendments of these statutes, the old statutes. Perhaps even changing the name of the old statute would have served the purposes. But what you have done, the greater damages that has been done, I squarely blame the advisors to the government. Certainly the government is looking for a better objective, achieving a better productivity of its applications, but certainly not properly advised, very, very badly and ill advised, where these sections of all these statutes are interchanged. Like, for example, you are sitting in your library containing about 1,000 pages. Your wife will come and change the entire setup of that particular chamber of yours, a library containing 1,000 pages. You are having a muscle memory about a particular content in particular rack, a particular number, a particular page, and you simply go there and find out that. That's how you created a muscle memory. And now your wife has changed the entire positioning of all the books, as this case happened, that the section 302, which is a punishment for murder in the Indian Penal Code, is now being given in section 103. Now what you do with that? Now that kind of except the fact that the entire provision is same, this section is changed. Now there are enforcement agencies are there are lawyers who will apply this law, there are courts. It's purely a case of a burden on the court, that the same content is actually interchanged its position in the form of a section and subsection, thereby putting enormous stress and the burden on the court, where the court, a small mistake, if the enforcement agencies have committed a small mistake, now what will happen? That particular mistakes, if he goes for a correction, it may take about 5 years or 4 years. You go right up to Supreme Court. There could be instances where the other party may even object to that particular correction, which he would like to take benefit of. So therefore, all the good work done is getting whittled out. Now, this is one small example. Now, there could be also n number of examples where the court would be forced to engage in discussions as to whether 302 is similar to 103 or not, and to what extent there are errors, or what extent there are even the corrections or the comma full stop is changed. Even what kind of judgments will have a application to the new law. Now, and what are the consequential changes happening in other provisions, how even that old judgments will have an application. Now that particular debate that may happen, because with a bona fide approach, the lawyers or the parties, they may even put it to the court's consideration. At the end of the day, the court is the final authority. When the parties before the court will agitate their case and refer to the sections and subsections, which is more or less the same, but you are engaging the court even to decide on this, that whether the old law will be applicable, the way new law will be applicable. Even though the law says that with effect from the repealing of this particular law, the old law will no more be applicable, the new law will be applicable. Even there are instances that what is the date of the cause of action, these are all matter of debates. And we always know that even if there is a repealing provision is there in every new law, the old law and new law interplay effects, they are always being put to the notice of the court and adjudication. Now that is exactly what I'm saying, that by bringing this new law, what you are trying to do is that you are burdening the court, you are burdening the system. The same system will be consuming more than half of its time. Therefore, I say that the court will be pushed back 4 decades old. It has a bearing and impact on the economy, because even the litigations which are happening even the individual level or the corporate litigations, that all happen, or we all know the Indian Evidence Act has its application across, whether it is a criminal law, whether it is a civil law, or whether it is a quasi law. Same is also the story with that the CRPC and IPC. Today, with the PMLA coming in picture, it doesn't create any distinctions between the civil jurisprudence and criminal jurisprudence. And that exactly way that in any particular case, you will be forced to put it to the court's notice, this adjudication process. Therefore, I say this, that this is very ill-advised to the government to bring about a law to the extent saying that this is absolutely identical, yet we are only changing the name and the quantum of punishment. Is it just and fair in part of a constitutional governance where a government is looking for a better alternative of governance, a effective and efficient governance, but in the process, unknowingly or innocently, committed a blunder by in fact impinging and injuncting the very process of adjudication and expecting the courts to decide these issues within a time-bound manner? How it will happen? For the same cause of action, for the same set of facts, for the same set of issues to be decided at the court, when you are adding another set of laws, what are you doing is, you are increasing base of adjudication for the court, consuming and wasting unavoidable resources engagement, with the infrastructure of the court remaining static, with the finite, and with the number of the litigations being finite. What you are trying to do is that you are burdening the court with a more set of laws, and to that extent, I have a strong reasons to give it to a legal proposition that even the constitutionality of this particular law needs to be tested on a new jurisprudential dimension as to whether a legislature having a power to make a law and bringing the same law with a new name, whether it will be a constitutional form of a correct and just and fair governance, or it is an arbitrary piece of legislation where an exercise of power for the purpose of the benefit of the population, people, is impeding the interest of the populations. This is something which all of us should ask and remember. This is not a case only for the lawyers. This is also not a case for only the enforcement agencies. This is also a cause of concern for the governing entities, the courts, the ordinary layman, which has a bearing because of the economic impact and impingement of these kind of a, though the government has no bad intentions, I have no manner of doubt in, and I'm not talking in a political rhetorical elements, I'm saying purely on a legalistic and fair dimension that the government may have all the best intentions to weed out the colonial era law. But the question is this how we achieve an objective? We may have addressed the colonial era law getting removed from the statute book. But what we are bringing in is that the entire content as it is. The best course could have been for the government, if at all, at this stage, this could have brought in all these changes, could have brought in through amendment. And if the government is really looking for change, the entire contours of the dimensions of the law of the British era or the colonial era laws, then the government has to come to the drawing room and design new form of a law, keeping in view the socio-political economic dimensions of this country and the 1.45 billion population's expectations. And that at the end of the day, it matters where? It matters with the pocket. It matters with your belly. As long as it is satisfied, as long as your economy is running and kicking, then only every institutional content can be protected. Otherwise, what we are bringing in is a kind of alternative mayhem to the system of a governance by impinging and burdening with an avoidable content, avoidable discourse. And that is certainly every individual's bereft of the politics should ask themselves and should engage the government for the purpose of the benefit of their own. They cannot be thinking of leaving it to the Ram Bharose that somebody will come, that some good things will do. In fact, the Honorable Prime Minister may be one of the most proactive Prime Minister, may be looking for finding better governance models for this country. That is what he ordinarily and initially said, that the minimalistic of governance and maximum governance, minimum government and maximum governance. And that you don't achieve this kind of through this kind of a legal discourse and impacting every millimeter of our private life, public life, space is occupied by 95% of the population's legalistic approach. Now, when the law is occupying so much of space of ours, now it is time for all of us to put our head together and assist all the institutional governance and entities for a better tomorrow. Please, I have a humble request to whosoever is listening to this, do not enforce this law till the time you understand what its spider's web impact, the multi-dimensional, multi-layer implications. This is profound. The judiciary will be pushed back to the 4-decade back, and the system will have an impact on the economy, impinging every individual in this country. Thank you.